Hi, everyone. Welcome to our webinar on emerging trends in cybersecurity and cryptocurrency. We really appreciate you taking an hour out of your day to be with us. My name is Laura Wasson. I practice in Dickinson's business, banking, and cyber practice groups. We're going to begin today's webinar with discussing emerging topics in cryptocurrency. Specifically, we'll be focusing on using cryptocurrency as collateral and various common cryptocurrency issues that we think banks and businesses should be familiar with. I will let John introduce himself and discuss his portion of the presentation.
Good afternoon, everyone. My name is John Lande. I'm the chair of our cybersecurity practice group. I also am involved in the banking and litigation areas, and we're going to be spending my segment of the discussion this afternoon talking about some of the trends we're seeing in cyber insurance coverage and cybersecurity generally.
Okay, so we'll just dive right in. Customers are beginning to offer their cryptocurrencies as collateral for loan transactions. And this section is going to focus on what that means for banks. First, I will discuss how to perfect a security interest in cryptocurrencies. Second, I will discuss why it's still a pretty risky idea. First, how to perfect a security interest, but we'll pause here for some background on cryptocurrencies. This is going to be a really broad overview. Cryptocurrencies are virtual currencies. They are not FDIC insured, nor are they issued or monitored by any government or associated with any central bank. They are based on a decentralized system whereby ownership and transactions are verified by other participants in the system. The so-called system or blockchain is free open source software. The first cryptocurrency to be available for public use was Bitcoin, which was released back in 2009. It was the only cryptocurrency on the market until 2011. At that point in time, one Bitcoin was worth about $1 US. Fast forward 7 years to today, Bitcoin is worth approximately $8,000 when I checked this morning. And despite being the most popular cryptocurrency, it now shares the marketplace with over 1,300 other cryptocurrency variations. Its cousin technology, blockchain, is also taking the market by storm. Blockchain is expected to have numerous uses as a foundational technology that, in essence, could save businesses and banks billions of dollars a year in backroom costs, all while apparently reducing fraud and facilitating real-time cross-border transactions that could occur 24/7. Since its arrival with Bitcoin in 2009, over 2,500 blockchain-related patents have been filed, and an estimated $1.4 billion has been invested in blockchain technology in the last 3 years alone. Its uses are being tested by all four of the big accounting firms this year, despite the fact that it's also fairly unregulated at this point. Back to cryptocurrency. To say that cryptocurrency market has exploded in the last 10 years would be an understatement. But why has this occurred? Many reasons, but first and foremost, because cryptocurrencies are still fairly unregulated, allowing companies to create them quickly, then sell them to consumers who trade them like stocks and utilize them like cash. But combine this quick rise to popularity with an unstable regulatory and legal environment, and you get one of the most volatile pieces of property that you can own. For instance, Bitcoins alone are estimated to be 8 times more volatile than the S&P 500 and 18 times more volatile than the US dollar. Despite this volatility, the versatility of cryptocurrencies continue to increase their popularity. Because of this, businesses are quickly lining up to accept them. In fact, over 100,000 merchants already accept Bitcoin, including PayPal, Microsoft, Expedia, Overstock, even Subway. Cryptocurrency's popularity can also be contributed to the fact that they are becoming easier to acquire. The most common way to purchase Bitcoin, for example, is not through a formal financial institution or other retailer, and it's not limited to those living in urban population centers on the coast. No, the most common way to purchase cryptocurrency is actually through a free app that can be downloaded on any smartphone. The most popular app in existence at the moment is called Coinbase, and it's simple and easy to use. I don't consider myself technologically inclined, but I've actually used the Coinbase app. I can tell you that it takes under an hour to sign up, verify your identity, link your bank account or credit card, and purchase Bitcoin, Litecoin, or the other main cryptocurrencies available on the Coinbase platform. People using the app can then track the value of all their cryptocurrencies in one place any time of day. In case you're wondering, I did not lay out $8,000 in cash to purchase a whole Bitcoin. That's the beauty of apps like Coinbase, which allows users to purchase fractions of a cryptocurrency. This has removed any financial barrier to entry in the cryptocurrency market, and when combined with the fact that cryptocurrencies are still fairly unregulated, this is why over 270,000 Bitcoin transactions are occurring each day. That number doesn't even account for the other 1,300 forms of cryptocurrency in existence that are constantly being traded. In sum, we're seeing cryptocurrency everywhere, and businesses and banks should be preparing to deal with them in lending transactions, but also in everyday customer interactions. This brings us to the first topic, the use of cryptocurrencies as collateral. Security interests in cryptocurrencies are perfected under Article 9 of the UCC. They are perfected like any other intangible. They are not perfected like money because the UCC definition of money requires that the currency be authorized or adopted by a government. As stated previously, cryptocurrencies are not tied to any government, yet alone authorized by them. Rather, cryptocurrencies are considered an intangible because they don't need to exist in a physical form to be exchanged, nor are they stored in a traditional deposit account at a bank. Instead, they are held in electronic wallets and identified by a private key. By way of comparison, other common intangibles include commercial tort claims, investment property, letter of credit rights, etc. As such, a bank may perfect a security interest in a cryptocurrency by filing a UCC-1 financing statement with the Iowa Secretary of State, like they would do with any other intangible. The financing statement must include a sufficient description of the cryptocurrency. This could be broad, like all cryptocurrencies, or narrow, like calling the cryptocurrency out by name, such as Bitcoins or Litecoins. This method of perfection could change as more courts and regulatory agencies begin to weigh in and define cryptocurrencies in this context. For instance, if a court were to determine that cryptocurrency is money, filing a financing statement would not perfect the bank's security interest. Rather, they would have to have control over the cryptocurrencies to be perfected. This is an area of the law with practical implications that we will keep an eye on as they develop. And for those of you that have experience in filing your own financing statement, I'll just show you some screenshots of what this would look like. This is a screenshot of the Iowa Secretary of State website. You can see up there at the top, you would click on UCC-1 financing statement. This is what the form looks like. It's the same form that you would use for any other financing statement to be filed. And then you would log in here. Now for part 2, why using cryptocurrencies as collateral is risky. The ability to file a financing statement and perfect doesn't necessarily make cryptocurrencies a good choice for collateral. That's because cryptocurrencies are difficult, if not impossible, to control. As long as cryptocurrencies are considered an intangible, control over them isn't required for perfection, but it is ideal. Yet control is difficult to obtain. Unlike funds in a deposit account, for example, a secured creditor can't enter into a control agreement with a bank or put their name on an account to ensure that the funds are not improperly used. In fact, given the manner in which cryptocurrencies are used, it may be impossible to prevent the transfer of cryptocurrencies without actually having control over and possession of the owner's private key. And if a cryptocurrency is improperly transferred, it will be difficult to trace. Sure, all cryptocurrency transactions are recorded in this public ledger, but the parties' identities are pseudo-anonymous. We know them by a number, for example, not a name. So catching up with a new owner of the cryptocurrency will be challenging. The other reason cryptocurrencies are a poor choice for security interests is their volatility. Put simply, a cryptocurrency's value may differ dramatically day to day. Take Bitcoin, for example. If you entered into a loan transaction with a customer who wanted to utilize Bitcoin as a security in December 2017, their Bitcoin was worth approximately $16,000 a coin. If they had 10 coins, the value of the bank's security interest was $160,000. Fast forward to February 2018, just 2 months later, one Bitcoin is worth approximately $8,000. In 2 months, you lost 50% or $80,000 of the value of your security interest. Of course, your luck could always go in the opposite direction, and the value of your security interest could increase, but there's too much uncertainty to predict what kind of luck you will have. The final reason cryptocurrencies shouldn't be your bank's first choice for collateral is because, practically speaking, so few people understand how to use them. Imagine the following scenario. Your bank has a perfected security interest in approximately $100,000 worth of Bitcoin. The customer defaults and it's time to collect the Bitcoin. In all likelihood, the bank doesn't have an electronic wallet to transfer the cryptocurrency to or an employee that knows how. Assuming it does have an electronic wallet, the bank is then responsible for converting the security to cash, and when should it do that? It's impossible to tell whether the cryptocurrency's value will increase or decrease on any given day, and if the bank converts at the wrong time, it could lose a significant portion of its security interest. In short, the takeaway is this. Banks can take a security interest in cryptocurrencies. They perfect their interest by filing a financing statement with the Secretary of State, and, if possible, taking control of the owner's electronic wallet and private keys. But doing so is risky. Cryptocurrencies vary in value on a daily basis, and if it is possible to take a security interest in a more stable asset, the bank should do so. The bank should also communicate with its employees about how to approach customers who offer cryptocurrencies as collateral. At the outset, that communication should begin with an education on cryptocurrencies. They are more than just Bitcoin, and employees should understand how to spot one of the 1,300 variations. The bank should also develop a cryptocurrency policy that discusses the volatility of cryptocurrencies and the risks associated with using it as the sole security interest in a lending transaction. That policy should be communicated to employees. So for the second part of this portion of the presentation, how to deal with common customer questions on cryptocurrencies. Cryptocurrency ownership is becoming so common that businesses and banks should strive for having a base level knowledge on a handful of common cryptocurrency questions or topics. So we'll conclude this portion by discussing 5 of the most common questions out there. First and most popular question, should I report cryptocurrency ownership on my taxes? Answer, legally yes, practically probably. The IRS has determined that for tax purposes, cryptocurrencies like Bitcoin are considered property. I want to discuss the 3 most common ways that cryptocurrency ownership could end up on your customers' taxes. First, as a capital gain or a capital loss associated with trading. Second, as income associated with accepting cryptocurrency as payment or wages. And third, as income associated with mining cryptocurrency as either a hobby or a form of self-employment. First, if your customer is regularly trading cryptocurrencies, they will likely have capital gains or losses from that activity, just like with stock. The IRS's policy is that those gains or losses should be calculated for each transaction, which requires your customer to calculate the fair market value of that cryptocurrency on the day it is received. Records of those calculations should be saved for at least 5 years. In addition, the customer must report any gain or any loss on the cryptocurrency, such gain or loss being a taxable event, if the cryptocurrency is considered a capital asset. Gains and losses of capital assets are reported on Schedule D to Form 1040 and Form 8949. The forms differentiate between short-term and long-term gain, which depends on whether your customer held the cryptocurrency for at least a year. If your customer is not inclined to do all the math themselves, there are actually companies like Bitcoin Tax that provide this service specifically for owners of cryptocurrencies. They're able to calculate these gains and losses by importing data from commonly used apps like Coinbase or wallets like Core Wallets. After the data is imported, they look at the owner's purchases, trades, and incomes to calculate the gain or loss reportable on Schedule D. Coinbase, for example, will even send users a Form 1099-K if they received at least $20,000 in cash related to at least 200 transactions to assist them in tax preparation. But regardless of how your customers get the information, the takeaway is that they should be doing the math and they should be reporting the gains and losses if they have them. Second, if your customer is reporting cryptocurrencies, is accepting cryptocurrencies as a form of payment for goods or services, they must include the fair market value of the cryptocurrency in computing gross ordinary income. If they are receiving cryptocurrency as a wage from their employer, The fair market value of that cryptocurrency is subject to federal income tax withholding, FICA tax, and federal unemployment tax, and their employers should be reporting that on their W-2 form. Third, if the customer is mining cryptocurrency, which is more common than you would think in Iowa, the income from that activity must be reported. Mining is the process of creating a new cryptocurrency. The income is based off the market price of the cryptocurrency the day that it was mined. The market price is also the miner's basis in the cryptocurrency. Going forward, that should be used to calculate that gain or loss reported on Schedule D if the owner sells or trades that cryptocurrency later. And the extent of the mining dictates how it is reported. Those who mine cryptocurrencies as a hobby just report the income as other income on line 21 of Form 1040. Those who mine cryptocurrencies as a form of self-employment report the income on Schedule C and get to deduct necessary business expenses like electricity, depreciation on mining hardware, and even the expenses related to a home office. Depends on how creative you want to get, I suppose. The downside of reporting mining as self-employment is that the income is subject to self-employment tax. Practically speaking, unless your customers' mining expenses are significant, they won't offset the self-employment tax, and it's probably more beneficial just to report that income on Form 1040. Many other rules exist that we're not going to dive into today, and various nuances exist within those rules, but the bottom line is that the customer should be advised that cryptocurrency ownership should be reported, and they should contact a tax professional to discuss the extent of that reporting. Practically speaking, though, because ownership of cryptocurrency is so difficult to trace, the risk of failing to report minor gains or losses from ownership is still low at this point, but I will say that the risk is growing. In late 2017, the IRS issued a John Doe summons to Coinbase, the popular cryptocurrency exchange discussed earlier, requesting that all customer records from approximately 2013 to 2015 be reported. The summons was eventually limited to accounts doing larger transactions, but the IRS was still able to obtain account records for over 14,000 users. In support of its investigation into cryptocurrency underreporting, the IRS has stated that only about 800 people properly reported cryptocurrency gains or losses on Form 8949 during that time. The takeaway is that the IRS is aware that cryptocurrency owners are underreporting or blatantly lying about their cryptocurrency ownership on their taxes, and they began gathering information on cryptocurrency owners in an attempt to catch them in that lie. While anyone who owns cryptocurrency should see a tax advisor, it's fair to say that the IRS is mostly interested in persons that have done over $20,000 in cryptocurrency transactions in the last few years. Second most common question. I heard about an opportunity to invest in a new cryptocurrency. What should I do? First things first, the Securities and Exchange Commission has determined that, generally speaking, new cryptocurrencies offered during initial coin offerings, or ICOs, are securities that must either be registered with the SEC or fall under an exemption from registration. This means that your customers should be thinking as investing in the new cryptocurrency like investing in the stock of a startup, not like purchasing a virtual US dollar. This is an all too common misconception that has led to several lawsuits and enforcement actions already in 2018. Therefore, you should convey to them the seriousness of the decision to invest and advise them to contact an attorney about the term sheet or the offering memorandum that they received. This should be reviewed for compliance with securities laws. For example, more likely than not, your customer would be considered an unaccredited investor that, under securities laws, is entitled to significant disclosures before investing in a new cryptocurrency. If an attorney has the opportunity to review the offering documents before the customer invests, they may be able to assist them in requesting those required disclosures and ultimately prevent them from investing in a bad cryptocurrency scheme, or at the very least help them make a more informed decision. The customer may also have a right to divest their new cryptocurrency and or sue the offerer if they determine after the fact that any of the offering documents contain fraud. Customers may not know that these options exist without being advised to speak with an attorney familiar with securities laws. The thing to remember here is that most customers still don't think of ICOs as securities offerings, and therefore They don't appreciate the risks involved or know their legal rights in connection with the investment. If a customer discusses any such opportunity with you, they should be advised to contact their attorney before investing. Third common question, does the FDIC insure my cryptocurrency? As a general matter, the FDIC does not insure any cryptocurrency directly. Of course, if a customer sells their cryptocurrency and puts that profit in a bank account, the FDIC insurance on that bank account is provided as usual. But if a customer holds their cryptocurrency through a mainstream storage provider like Coinbase, some insurance is actually provided. According to Coinbase, all of the user's cryptocurrency stored online is insured against theft. But to be fair, only 2% of Coinbase users' cryptocurrency is stored online. In conclusion, ownership of cryptocurrency is risky and it's highly unlikely that your customer's cryptocurrency is insured against theft, hacks, or other losses. A fourth common question occurs when someone is trying to get a loan from a bank. Customers are asking, I have $20,000 in Bitcoins, or I mine Bitcoin regularly. Is this an asset or a demonstration of income that I can use in trying to get a loan? Answer, it depends. Banks must come up with their own policies on how cryptocurrency ownership or mining plays into the underwriting process. They should consult their lending and compliance officers on this topic, as the FDIC has not directly spoken to it yet. As previously mentioned, mining is the term used to describe the process where new Bitcoins or other cryptocurrencies are created. Those that want to mine Bitcoins have to purchase tens of thousands of dollars worth of hardware that, at least for the moment, is a really valuable asset that should be considered in their net worth. In addition, even though mining is less fruitful than it was a decade ago, it's still a source of income for those who mine on a regular basis. But as stated previously, the value of cryptocurrencies and the mining equipment changes dramatically from day to day. For banks, the conservative approach is to ignore Bitcoin-related assets or income when determining whether to loan funds to a customer, or to the extent they are considered, they should be near the bottom of the list or given a fraction of the value asserted by the customer. Nobody's really going to ask this fifth question, but it is worth talking about. Are there any issues with using cryptocurrencies internationally? Answer, yes, there can be. The Office of Foreign Assets Control, or OFAC, enforces trade sanctions through comprehensive embargoes with various countries, including Cuba, Iran, and North Korea, and through its specifically designated nationals, SDN's list, which identifies people and entities with which U.S. residents are prohibited from doing business. OFAC doesn't require U.S. citizens to screen every person they do business with overseas to determine if they're a prohibited party, but they nevertheless broadly sanction those who they find doing business with prohibited persons, and they can be subject to significant civil fines and criminal penalties. This becomes an issue in the cryptocurrency and blockchain context because crypto transactions on the blockchain are pseudo-anonymous. You might trade cryptocurrency with another party identified by a number, as previously stated, not a name. Customers should be aware of the consequences of doing business with the wrong party and do what they can to determine the identity of any non-U.S. persons and businesses they trade or transact business with. These are some of the most common questions that are being asked right now, or that should be being asked right now, by the average cryptocurrency owner, and we hope that the discussion here provided will be helpful to you in your dialogue with customers. Of course, it goes without saying that the cryptocurrency and blockchain area is new, and regulatory agencies are coming out with new policies regarding cryptocurrency ownership on a regular basis. We'll keep you updated on those new policies and details on enforcement actions on Dickinson's cybersecurity blog.
Thank you, Laura. We're going to shift from cryptocurrency to talk a little bit more about some other trends in cybersecurity, and in particular cyber insurance, because that's an area that continues to be, from my vantage point, hotly litigated and little understood, particularly by the folks out there in the marketplace who are actually purchasing insurance. Just in general, I want to talk about the cost of cybersecurity incidents. The information I've got up on the slide now is a recent study put out by IBM that surveyed 63 different companies to identify the total cost of a security breach. And the primary focus of this data was to look at the cost in terms of employee records or customer records that were stolen. For many organizations, that's their primary risk when it comes to cybersecurity, is that customer data or employee data will be compromised, and they'll be forced to send out data breach notices, or in some cases to provide identity theft monitoring and other services like that. As financial institutions, your risks not only include the risk that you've got your employee information and that it could be compromised, but also the risk that the account or depositor funds that you're actually holding could be compromised. And so not only do you have the risk that's displayed up on the slide, but you've also got an additional source of risk that if your systems are compromised, individuals may lose money that they're storing in the bank, which creates a whole host of issues. One of the issues that insurance companies are finding as they venture into the cybersecurity realm is the concept of moral hazard. And one of the things they're very concerned about is that overly broad coverage will encourage poor cybersecurity practices. Moral hazard is simply the concept that when you remove the incentive to protect yourself from a loss, people tend to act in a very careless way. And when we're dealing with someone else's property, or when someone else is going to have to pay for the loss that is incurred, it can encourage reckless behavior on the part of the insureds. And I think if you understand that that is the insurance carrier's perspective, then you can start to understand that or understand why it's so difficult to purchase cyber insurance products that provide blanket coverage for your organization to protect your organization against any conceivable cybersecurity risk or threat. The fact of the matter is, what we see with quote-unquote cybersecurity insurance coverage is that it may sound like it covers you broadly, but the specific areas of coverage are actually quite narrow and are tailored to only cover certain kinds of fraud and loss that your organization might suffer as a result of a cybersecurity incident. What's important to do as an organization is view insurance as the last line of defense. Cybersecurity risk mitigation needs to include a layered approach where you have multiple lines of defense in place that reduce risk at every level. And so by the time you get down to insurance and looking at whether or not your insurance covers a particular loss, you should only be dealing with a fairly narrow range of potential sources of loss. That should make the insurance much easier to purchase because you've identified what are the riskiest areas of our organization and what are the most important parts of our organization to keep secure. So in the case of a financial institution, you are most concerned about, or should be most concerned about, depositor funds and making sure that you have a layered system of defenses to ensure that depositor funds are protected and that ultimately you have insurance that will cover a loss of depositor funds. In contrast, while it may be terribly embarrassing for your organization if something happened to its website, the website typically, even though it's public-facing and the public image on the internet, is not critical to the organization's overall integrity. And so if something happens to the website, you may not need to have any kind of insurance in place to cover that loss because that's something that can be repaired fairly easily and doesn't really expose the organization to any risk, depending on how it's set up. What you need to do inside your organization is make sure that you've got a system of controls in place to ensure that certain critical functions cannot occur unless multiple people are involved or multiple systems are involved. And so for a financial institution, what that would mean is the wire department in the organization that's responsible for sending out wires from customer deposit accounts needs to have a series of protocols and controls in place that will ensure that any money that leaves the bank via wire is, in fact, really authorized to leave and is going to the right place. But losses will inevitably happen. I work with a number of financial institutions around the state and other businesses that have been targets for cybersecurity incidents. And in those cases where money is lost, I've seen losses ranging from tens of thousands of dollars all the way up to six-figure losses. And the smaller losses are much more frequent than you might expect. I think for a lot of organizations, the feeling is that cybersecurity is really a concern for large organizations, large corporations, multinational entities that have operations in places in the world that may have more lax rule of law, and so there's more opportunity for cybersecurity fraudsters. But the reality is that cybersecurity fraudsters really don't care what the size of your organization is. If you think about how many different cybersecurity frauds a fraudster can have going on at any one time, it's really limitless, depending upon the number of fraudsters involved. They can really target a whole variety of organizations simultaneously. And if they're able to get $10,000 from one organization and $30,000 from another organization in the same morning, that's a pretty profitable morning for them. So the size of the organization doesn't really matter. And so that means losses are becoming more and more common, particularly when we're looking at something called corporate account takeover, where fraudsters are able to trick either a bank or a business or some other kind of organization into sending money out to some place that it shouldn't be going. And so when we have one of those losses, first and foremost, you've got the option to pursue the hacker, the fraudster, if you can find that individual. Very often, though, they're in a country that doesn't have an extradition treaty with the United States, and so not even the FBI can go get those individuals, and so you really don't have an option for recovering from them. At that point, you've got to look for alternative sources of recovery. Financial institutions, in some cases, may be able to seek indemnification from the depositor, depending upon the agreements that you have in place with your depositor. If the bank, accepted a payment request that came from a depositor and followed that request and sent the money out, and later it turned out that the depositor had been tricked by somebody, the bank may not be liable in that circumstance. Or there may be other sources of indemnification. If you've got vendors that were maybe responsible for the breach, they may be able to be looked to as a source for recovery. But if not, you're going to be looking at insurance. And to really highlight the issues that we see when we're talking about cybersecurity insurance, I've got a couple of case studies that we're going to walk through to show where the problems are and where the litigation is with cyber insurance, to give you an idea of what you need to be looking for out there on the cyber insurance marketplace. One of the main problems we have with cyber insurance is that there's two broad categories of coverage, and they tend to be exclusive of each other. And so what we'll find is that a lot of quote-unquote cybersecurity policies provide coverage for hacking, what's typically called computer fraud coverage. That kind of coverage is designed to provide coverage for situations where there's unauthorized access to your organization's systems. This is what we traditionally think about when we think of hacking. It's somebody sitting in a dark room with lots of LED server lights blinking in the background, tapping away at a computer, breaking through a firewall, gaining access to the organization's systems, and then using that access to transfer money out or transfer employee records out. That was what a lot of cyber insurance was written to cover initially, but what we're finding is that a great number of the losses today are actually the result of what's called social engineering. Social engineering is kind of a broad catch-all term, but generally refers to situations where fraudsters may use some combination of access to your systems along with correspondence with particular employees to trick employees into doing things that they shouldn't. And typically that involves sending out confidential information to the fraudsters, or having the employees initiate a wire transfer on behalf of the organization to send money out of the organization's bank account. In fact, the social engineering fraud has really become so common that we've seen a number of cases where people in HR departments of organizations have been tricked into sending just entire spreadsheets of employee information that include employee names, addresses, social security numbers, or even employee W-2s to fraudsters. Fraudsters will impersonate either the CFO or CEO of an organization and send an email to HR saying, hey, can you send me this stuff? And then the HR employee will dutifully comply with that request because they think it's really coming from the CEO or CFO, when in reality it's coming from fraudsters. The computer fraud coverage that we typically see in cybersecurity policies is fairly narrowly drafted so that it really is intended to cover situations where those fraudsters actually gain access to your network or to a computer on your network. And the argument that insurance companies make is that in the context of a social engineering loss, fraudsters may trick an employee into clicking on a link that causes malware to be downloaded on a system. The fraudsters will accomplish that by sending the employee an email, either from another person inside the organization or from outside the organization, and that email will appear legitimate to the employee. It'll either be from a customer that employee typically interacts with, or it'll be from a superior inside the organization. And either the fraudsters will have gained access to that superior's email, or they will be impersonating that superior's email from outside the organization. There are a number of tools that allow fraudsters to make their emails that are sent from outside your organization appear to be from people inside your organization. And so when those employees get tricked by those emails, maybe even into installing malware on your system, the insurance companies argue, well, that loss that you experienced wasn't really a consequence of any unauthorized access to your systems, because the employee actually granted the fraudsters access through their voluntary action. And our insurance coverage isn't designed to guard against employee, for lack of a better term, stupidity. Our insurance coverage is only intended to cover situations where your system is actually compromised by hackers. And the fact that an employee intervened in that process and voluntarily granted access means that it's really the employee that's responsible for the loss and not the fraudsters themselves. To illustrate how hard these cases can be to litigate if you're an insured who suffers a loss, I'll compare two different factual scenarios where companies tried to get coverage under computer fraud loss protection for what was probably a social engineering loss. Metadata is a really important case in this area because the issues are so clearly presented to the court, and it's an easy case for us to follow along. In metadata, fraudsters actually sent emails into an organization's accounting department to convince employees to send money out to the fraudsters. The fraudsters didn't actually have access to the company's internal email servers or internal network. Instead, the fraudsters were able to spoof emails from outside the organization. What they did was they set up a system that allowed them to send emails into the accounting department, and they inserted code in the headers of those emails so that when those emails arrived in the inbox of the company's accounting department, they actually populated the email address of the executive that the fraudsters wanted to appear to be sending email on behalf of. And not only did it populate the email address of the executive, it actually included the photo of that executive. This particular company's email system was set up so that, any internal email that was circulated through the organization would have the sender's photograph appear next to the from email address. So the accounting employees, understandably, were taken by these spoofed emails and convinced that they were really receiving emails from executives inside the organization. These quote-unquote executives told the employees they'd be getting a call from a lawyer who would provide them with wire instructions. So the employees received a call from somebody who claimed to be a lawyer, and then actually proceeded to wire out $4.7 million to a bank account overseas, according to the email and the lawyer's request. Metadata then sought coverage under a computer fraud clause, just like the one we looked at on the slide before, and the insurance company denied coverage. The insurance company denied coverage for two reasons. First, they said this was a result of voluntary employee conduct. And then second, they said there was no actual alteration of the company's hardware. There was no unauthorized access that was granted to fraudsters, even though the fraudsters had inserted malicious code into their emails that caused the emails to appear to be coming from executives inside the organization. So Metadata and the insurance company sued each other, and the district court actually ruled that this fell within the computer fraud coverage provision of Metadata's insurance policy. So that was good. Metadata prevailed. What was important to the court was the fact that fraudsters used code that was inserted into the headers of the email messages that were sent to the accounting department. And the court found that that was computer fraud within the meaning of the policy. We should temper our jubilation, however, because this case was appealed by the insurance company to the Second Circuit Court of Appeals, and that case is still pending. So we don't know how the next court is going to view this case, but at least for now, Metadata has prevailed. So let's contrast that with another case involving a company that had a computer fraud coverage provision and experienced what is likely a social engineering loss. So American Tooling Center involved a tool and die company, and the way this company ran its business, it would receive orders from people that wanted different tools and dies manufactured, and then it would actually engage a Chinese company to do the manufacturing of these items and then ship them over to the United States. And so the company would routinely send orders to its Chinese manufacturer via email. And the Chinese vendor would then turn around and send back an invoice that needed to be paid. And so it was routine for this organization to not only send and receive communications from China, but also wire money to China and receive products back from China, which really presents a problem from a risk management standpoint because financial institutions, I think, typically would identify any transaction to or from China as being a high-risk transaction, and in a lot of cases would likely be an indicator that a fraud is occurring. But here, this particular organization's financial institution would need to find some other way to risk score transactions to and from China because they're a routine part of the company's business. So getting back to the facts of this case, Chinese vendor would email invoices back to the organization for payment. Fraudsters were able to obtain or intercept those invoices. They either had access in China to that manufacturer's systems, or they were able to intercept them in transit. And so they saw that there was all this traffic going back and forth between this U.S. company and this Chinese manufacturer. And so they actually impersonated the Chinese manufacturer and sent an email to the president and CEO of the tool and die company based in the United States and requested, or actually responded to the president's request for all outstanding invoices. So the president had sent an email to the Chinese manufacturer asking that the manufacturer provide all outstanding and unpaid invoices. So the fraudsters did that. They actually obtained all of the outstanding invoices from the Chinese manufacturer and sent them back to the U.S.-based company and said, here it is, you owe us about $800,000, and oh, by the way, we have a new bank account. So please send all payments to this new bank account. this actually is an increasingly common kind of fraud where fraudsters will notice that a company or organization routinely makes vendor payments. And so they will impersonate that vendor and tell the company or organization that the vendor has a new bank account. And so companies a lot of times will have set up automatic payments, and those payments will go to the fraudsters for 2, 3, 4, 5 months before the vendor and company finally figure out what's going on. And that's sort of what happened here in this case. So there was an $800,000 loss. The tool and die company made a claim on its computer fraud coverage provision, and it was denied coverage. And if we compare Metadata to American Tooling Center, we see that there are some similarities. For example, in both cases, employees received emails from fraudsters that appeared to be coming from legitimate senders. However, the way those emails were sent was substantially different and materially different from the standpoint of insurance coverage. So in Metadata, fraudsters actually inserted code into the headers of their emails so that the emails appeared to come directly from the officer they were impersonating. However, in American Tooling Center, the fraudsters weren't that sophisticated. So instead of actually sending emails on behalf of the real Chinese-based manufacturer, they created fake email addresses that used a combination of letters to make the domain appear to be the same as the real Chinese manufacturer. So if you look at the slide there, the real domain was mold.com, and the fraudsters registered email addresses at rnould.com. And the RN, because of their proximity, appeared to, at a glance, look like an M. And so the way this was really a low-tech fraud. And that was important because the court concluded in American Tooling Center that there was no unauthorized access granted to American Tooling Center's computer system. They just got tricked into sending money to the wrong location. And so their claim was denied. And so what we see here is a very similar fraud, in fact, really the same fraud, perpetrated against two different organizations. But the way that the fraudsters went about committing this fraud resulted in a material distinction in insurance coverage between these two organizations. And that makes it very difficult for insureds when they're trying to purchase insurance coverage, because in this circumstance, you're not really insuring a particular asset. You're insuring against a particular kind of fraud happening. And here, it's not even the category of social engineering. It's the way that the social engineering or the fraudsters decide to engage in the social engineering. And so what that means for somebody like American Tooling Center is they need to pay really close attention to what their insurance coverage actually covers. And in this case, they would have been better served if they'd had coverage for social engineering. So the issue in all these cases is whether social engineering and voluntary employee actions were sufficient to break the chain of causation between the fraudster's actions and the loss. And in all of these cases where organizations are trying to get coverage under a computer fraud coverage provision, the insurance companies are arguing that employee voluntary conduct is not covered, and that organizations need to have social engineering coverage if they want to try to have those losses covered. So when you're shopping for insurance coverage, there are several things that you should be on the lookout for. First and foremost, you want to make sure you've got coverage for first-party loss. First-party loss would be, for example, if you're a financial institution, a situation where money leaves your general ledger account that maybe you have that you fund loans through. Whereas third-party loss is going to apply to situations where you lose something that belongs to somebody else. So if you have employee data like W-2s or customer data or customer funds, and those are lost somehow, either because your system was compromised or because a vendor or somebody had their system compromised, then you want to make sure you've got coverage for third-party loss. you want that coverage to include as much forensic investigation as possible, because the forensic investigation costs can get really high really quickly. If you discover that your organization has been the target of an attack and fraudsters have gained access to your systems, it's very difficult and very time-consuming for forensic investigators to come in and determine what systems fraudsters had access to and then make sure they're cleared out, because they're trying to prove a negative. They're trying to prove and identify the systems that do not have any indicators of compromise, and that means they have to go through everything. And so that cost can run up rather quickly. In the event that you've got customer information or employee information that was compromised, you may want coverage for providing notice to those individuals that their information was compromised. 48 states, the District of Columbia, Virgin Islands, Puerto Rico, all have data breach notice laws, some of which are incompatible with each other. For example, the state of Iowa has a notice law that, if you complied with it, would violate Massachusetts law. And so that can get expensive depending upon the breadth of the notice that you have to provide. You want to make sure that you've got coverage for voluntary acts of your employees. And what I mean by that is you've got social engineering coverage. And you also want to understand what the scope of that social engineering coverage is. You know, at what point is it going to stop? And so what degree of training do you have to provide to your employees to make sure that they do the minimum necessary to ensure that you still have insurance coverage? And then you also want to look at crime fraud and some other lines of insurance that are more mature, that because of the way the policies are worded, may still provide coverage for cybersecurity type losses, depending upon the way that those losses occur. Knowledgeable insurance agents are invaluable when shopping for cybersecurity insurance because they're really going to understand all the different policy options. It's also helpful to consult with an attorney. If you've got policy language in an existing policy and you aren't sure whether or not it covers a particular area of your organization, an attorney can certainly help with that coverage. But ultimately, insurance is only going to be a last line of defense. And so what you really need to do is you need to identify what are the greatest areas of risk for our organization, the so-called crown jewels inside your organization, because those are the items that you want to make sure you've got insurance coverage for. Could be your bank accounts, could be the payroll account, it could be personally identifiable information for your organization's employees or customers. You may have trade secrets and other information that you don't want to have publicly available, and then anything else that really generates revenue for your organization. For example, if you are the target of a ransomware attack where fraudsters get in and install malware that causes you to be locked out of your system unless you pay a ransom, you may want to have business interruption insurance that covers cybersecurity incidents. I don't know if anyone's following the news, but the city of Atlanta is currently dealing with a ransomware incident where they are fraudsters are asking for $50,000 in order to unlock the computers for the city of Atlanta. And so it's a problem that is proliferating just proliferating. It's pretty easy for fraudsters to get their hands on ransomware and some of these other kinds of malware, and then it's pretty easy for them to turn a profit, because for most organizations who don't have backups or adequate insurance, they really are held hostage. So we certainly have time for questions now if you want to type them in the chat box, or you are certainly, please feel free to email Laura or I, and we will be happy to get in touch with you. Okay. Doesn't look like we have any questions right now, so please feel free to email either me or Laura, and as Laura said, be checking our cybersecurity blog. We have a number of topics or posts about cyber insurance, about cyber liability, Bitcoin, and some other compliance issues. So thank you very much for your time.